There's a period of time as it relates to the criminal case when it's appropriate for the defense attorney to bring motions on behalf of their client. Some of those might be after the arraignment, shortly after the defense attorney has had an opportunity to start reviewing and getting involved in discovery. They might find that there's a particular motion that they need to bring on behalf of their client. Maybe it's going to relate to some kind of evidence that they want to get excluded. Maybe it has to do with a violation of the right to counsel or something as it relates to a statement. In all of those motions, the attorney is filing the motions, bringing the motions in an effort to try to improve the case on behalf of their client. There are times where maybe because of a potential legal issue, a defense attorney might bring a motion to dismiss. And if successful, that type of motion would end the case. And so a good criminal defense attorney who knows what they're doing is going to carefully research the case, make sure they're up to speed on the facts, and then bring any applicable motions that can help benefit their client. We hear the term plea negotiations, and sometimes it has a connotation as something bad. Some prosecutors like to use the term negotiated disposition, but in reality it all means the same thing. 90% or more of all criminal cases end up getting resolved in some type of way prior to going to jury trial. And the reason behind that is because if reasonable people, lawyers, clients, judges, if they sit down and they review a case carefully, usually there's an agreement upon what happened to some degree. And there's an understanding of this is what the facts would show. The criminal justice system is also heavily impacted and notoriously overburdened. And so there's an incentive to try to get cases to resolve before going all the way to jury trial. Otherwise, if every case went to jury trial, the system would simply break and shut down. And so a lot of times through plea negotiations back and forth involving the prosecutor making offers to the defense, as well as the defense making counter offers to the prosecutor, many times the parties can agree on a lesser charge or some kind of sentence that is fair considering all of the known facts and circumstances. When that happens, a criminal defense attorney spends the time to carefully discuss any offers and counteroffers with their client, and ultimately the client is the one who's in control of whether or not to accept a deal, to accept some kind of plea negotiation, or to reject that and instead go forward to trial.